Hello, people. I just wanted to say hey, and I hope everybody is enjoying your life. So I'm going to bring a video and I'm going to go over a few things in regards to loans or alleged loans, and I'm going to make some clarity to you for you so you understand what you're doing out here in these commercial streets. All right. And today my fragrance is Must Ravageur, and we're going forward. Okay. So some things that people need to understand is what a document of title is. A lot of times people just tell you you need an MSO on your car or MCO on your car, and they're completely oblivious and ignorant about the fact that any document can be a document of title as long as it references uh, property, goods, or a claim. So whenever you send documents in regards to asserting a claim, these documents can constitute as uh, a document of title. Okay, so you don't need an MSO to have ownership of your car. Ownership is an illusion. Okay, you can't own anything. All you can do is control your interest in it. Okay, so documents of title, whereas negotiable instrument embody a claim for the payment of money. Documents of title embody claims to goods. The most common such document are bills of lading and warehouse receipts. A bill of lading is a receipt for goods delivered for transportation by a ship. Well, you notice when you receive something in mail, they always say shipping, but you're not receiving it by shipping. You're receiving it by transport. Why would they call it a shipping? Well, because it's under admiralty. Okay. When you're doing certain transactions, you have to understand what admiralty and maritime law is. Okay. On receiving the goods alongside or on board, a doc or mate receipt is issued and is later turned in for the bill of lading proper. The bill of lading may certify receipt of the goods either on board of the ship, shipped on board, or alongside received for shipment. This later form of bill of lading is less valuable since it does not prove the fact and date of the loading. Apart from proving the receipt of the goods to be shipped, the bill of lading incorporates the terms of the contract concluded between the carrier and cosigner for the transportation of goods to the port of destination. Now, when you receive a statement, this is a statement. So when people say, you hear things where you hear people say, well, I didn't ask for a statement, I want a true bill. Okay. The true bill actually it takes precedent over a statement. Okay. So when you understand these things, you're like, okay, this makes a lot of sense to me now. A great many of printed clauses on a bill of lading purport to excuse the carrier from liability for delayed delivery or from liability for damage to or loss of goods. Remember, okay, when you receive a statement, it usually has terms and conditions on the back. Most people never read their terms and conditions on the back, and then they wonder why they don't get remedy. These clauses are valid, however, only if and insofar as they comply with the applicable national law or, in case of ocean transport, with the Brussels Convention on Limitation of Liability, 1923, amended in 1968, that incorporates the Hague Rules, which have been adopted by major shipping nations. Subject to these contractual terms, the consignee, the person to whom the goods are being shipped, meaning you. So whenever you receive a statement, it is considered to be shipped to you, even though it's being mailed. Okay? May by virtue of the bill of lading demand delivery of the transported goods at the port of destination. In the simplest case, the cosigner sends the bill of lading by airmail to the consignee that the latter may claim the goods on arrival of the ship. The carrier may only deliver the goods to a person holding a duly negotiated bill of lading. A bill of lading and the claim it represents may be transferred to another by endorsement and delivery of the document. If made out to the bearer, which rarely happens, the bill may even be transferred by mere delivery. By such transfer, all the rights and obligations embodied in the document are transferred to the new holder. The latter is entitled to demand delivery in goods of the goods unless the carrier provides that the holder knew or through gross negligence was unaware of the transfer's lack of title in the bill. In contrast, the rules on negotiable instruments and endorsements of bills of lading does not make the endorser liable for any default of the carrier's previous endorsers. The bill represents the goods and the transfer of the bill, therefore equivalent to the delivery of the goods to the transferee. It depends on the intention of the parties, whether ownership in the goods are merely a security interest in them is to be transferred. A security interest is typically acquired by a bank, which gives credit on the security of the shipped goods. See, when you're receiving a statement, the bank is giving you credit. Okay, they're giving you credit, but they're not crediting your account. So you have to force them to credit your account. The above rules on the bill of lading, though not formally unified, are essentially the same in all seafaring nations. Most of them also apply to the bills of lading issued in river navigation. The warehouse receipt is a document that shares an essential traits of a bill of lading, except that the duty of the transport the duty to transport the goods is replaced by an obligation to store them. So when you go to jail and they take all your stuff and then they bind it or keep it, what they do is they do a warehouse receipt. So if you're going to jail or prison, it's a warehouse receipt. If you're going into a court, the complaint acts as like a warehouse receipt. Okay. Uh, According to the intention of the parties, such transfer may pass ownership in stored goods or create other rights, such as a security interest in them. Okay. So, letters of credit. Of great importance in international trade is the letter of credit. A letter of credit is essentially an authorization made by a buyer to his agent, usually a bank, to make payment to a seller. The letter of credit comes in use when there is substantial time lag between the dispatch of goods by a seller and their receipt by the buyer. The seller, having sent the goods off, has fulfilled his part of the contract and seeks payment. The buyer, not having received the goods and being unable to inspect them, will be reluctant to pay. To overcome this difficulty, the buyer and the seller make arrangements to have intermediaries operating in each of the two countries involved in make settlement. The buyer instructs his bank to issue a letter of credit authorizing payment to be made to the seller when the latter's part of the contract has been fulfilled, usually when the seller has dispatched the correct quantity of conforming goods. The buyer's or issuing bank ascertains whether or not this has been done by obtaining the cooperation of the banks in the seller's country. I don't know why this prompt always pops up and I have to change that. But at least I got ad block on here. Okay. Seller's country. This bank, the correspondent bank, having having inspected all relevant documents of title and bills of lading to ensure that the seller has performed, makes payment to the seller, often means by means of bills of exchange or other credit advice. The documents of title, bills of lading, and so forth are then mailed to the buyer. The buyer then reimburses his bank, which in turn reimburses the corresponding bank for making payment to the seller. In no other branch of international trade have efforts of unification of law been more successful than in the letters of credit. In 1933, the International Chamber of Commerce in Paris published the Uniform Customs and Practice for Documentary Credits. Okay, you guys need to read this. Okay, when I'm saying this, please read it because I'm actually looking it up myself. This is the beautiful thing about learning this stuff because the more you read it, you might find documents that you never even knew existed. And I've been studying this for over 8 years and I still be finding new stuff, right? So, which was revised in 1951 and 1962, once again in 1983. It has been adopted by banks and banking associations in almost all countries of the world. So now we're going to go into loan. And I kind of like Britannica because like there's certain sites that I use, like you might see me use Wexlaw because I already know this stuff, but a lot of it is like I still learn new stuff just by going on Wexlaw or Britannica. You might learn some cases and it makes it easier for me to present it to you guys instead of me just going over all kinds of cases and reading case law. I mean, come on, man, I don't got time for all that. Loan of money, okay? Second only to sales, the lending of money is one of the most frequent types of commercial transactions. No developed economy could exist without credit financing or industrial investments of commercial transactions or of private acquisitions. A lender gives money to the borrower who is obliged to repay it and to pay interest as well. Interest is thus the price for the utilization of the lender's money. The payment of such a price has not, however, always been regarded as permissible. For centuries, the medieval Christian church stigmatized interest as income without true work and therefore sinful. Religious restrictions on interest are to this day of great importance in Islamic countries. In socialist countries, the lending of money against interest, except through state banks, was strongly discouraged. A loan is a contract between lender and borrower. It may consist of immediate giving of money against the borrower's promise of repayment. So you notice when I say something like your child support is prepaid, your car is prepaid, it's not prepaid because of HR 192. It's prepaid because of your borrower, your promise. Once you promise to pay something, that constitute as payment. So people, HR 192 does not discharge any of your debts. So people will regurgitate this. It's the fact that you gave them a promissory note, which means you have a proprietary interest. You agree to insure them against loss. Okay, that's why they send you statements, and you're supposed to validate the statements and say, okay, these statements are correct, and endorse them for payment. Okay, so all this stuff where people say you got to put UCC one that they don't understand the game. Okay, or the contract may contain a promise of the lender to give the money at a future date. In the latter case, it may sometimes happen that a borrower must sue an unwilling lender for performance of the promise to make the loan. Listen to what I'm saying. I'm going to wind that back up. In the latter case, it may sometimes happen that a borrower must sue an unwilling lender for performance of the promise to make the loan, as in the comparable situation of non-delivery and sales contract. Anglo-American law and also that of some countries refuses an action for specific performance and provides merely for damages, whereas most of the legal systems of continental Europe admit such an action. Specific performance of an agreement to take a loan may uh, similarly be enforced against a borrower in most civil law countries, but not under Anglo-American law. Interest on loans is today generally omitted among merchants. It often must be paid, even if not expressly agreed by the parties, since no merchant is regarded as willing to lend money without receiving interest thereon. Many countries fix the rate of interest to be applied in such cases. This legal rate has frequently been somewhere between 4 and 7%. Modern legislation sometimes establishes fixable rates, such as 2% above the fluctuating official discount rate of the country. Many countries also limit the maximum amount of interest that may be charged, even if both parties have agreed on the higher rate. If the maximum figure has frequently been between 6 and 12%, but in certain countries goes up to 30% or more. The usury statutes, remember the usury statutes. So if you're paying high interest on loans and cars, you can also bring up usury, are likely to be circumvented by lenders who demand considerable sums as commission or expenses. More flexible, but also less certain, are general laws declaring certain usury transactions null and void. So you have to raise that on things like child support and other stuff. Okay. Like, well, child support is not going to reference interest, but technically, I mean, come on. Almost everything is interest. So if a borrower does not repay a loan, because you have to understand what I'm saying, almost everything is interest, because you're not loaning any money. When you go into a borrower or when you go into a bank or a financial institution, they're not lending you their money. So what they're doing is creating a security, and then they're using a security interest to mitigate specific performance. If a borrower does not repay a loan by the agreed date, he must reimburse the lender for his loss. Without even having to prove a loss, the lender at least entitled to default interest. That is interest accruing after the due date of repayment. Some countries permit the lender to claim additional damages, whereas others exclude them. A few countries, notably the United States, have established special rules regulating loans to consumers. This has usually been in response to abuses to which consumers have been exposed in connection with installments, sales, hire purchase agreements. Okay, this is where people get the W-4 sandwich. Okay, so they're not wrong with the W-4 sandwich, because if you're in debt to someone, you're actually working for them. So you can report that on a W-4 as income, gross income, or income not received. But yeah, you can report that too, because when you do a loan, you're actually working for somebody. Okay, but I'm not getting into the W-4. I'm just trying to get through all of this and power through this so you guys have an understanding. Security on loans. In the event a borrower's bankruptcy, the lender may have to share the borrower's assets with competing creditors and may receive only partial satisfaction or even none at all. Lenders therefore urge borrowers to give security for the loan unless the credit standing of a specific debtor is free from any doubt. A security interest on goods called collateral entitles the creditor to satisfy his outstanding claim from the charged good to the exclusion of the other creditors of the borrower. Hence, a security interest gives the secured creditor a right of preferential satisfaction from the goods charged with the security interest. The demand for security on loans varies from country to country. In general, the demand is greater the more developed the credit system is. But even among countries having a comparable credit structure, there are variations. Thus, certain countries, especially France, put legal obstacles in the way of modern forms of security, whereas others have recourse to various forms of personal security. The oldest security device is common everywhere is the pledge or pawn. See, when you give a promissory note, you are pledging something. When you do a child support case, a traffic ticket, all of this is considered a pledge. That's why when you get a traffic ticket, it's a notice to appear. That's a pledge. Okay, the borrower delivers the goods to be charged to the lender, who keeps them until repayment of the secured loan. The security device has become rather outmodeled today and is utilized only in relative few situations. But pawnbrokers continue to operate on a minor scale, and banks keep documents of title such as properties, deeds, and securities. The decisive drawback of the pledge is the necessity of transferring the goods to be charged to the lender. Hence, the borrower cannot use them for production, sale, or lease. There has thus been a trend away from the pledge to other forms of security, by which the goods charged remain in the hands of the borrower. Many new devices have been introduced since the latter half of the 19th century, and they vary considerably in their operation. For want a common descriptive name, they will be referred to as no pledge devices. They all attempt to overcome the problem posed by the fact that third persons relying on the outer appearance of a well-funded borrower have no means of knowing whether or not the borrower's assets are in reality already charged in favor of another lender. The most common method of warning third persons against existing security interests has been their registration. So it's key. You have to understand how to register your property correctly. Otherwise, it's considered abandoned property. Okay, you have to read the doctrine of discovery. Please, people, read this. Goods are so charged are entered into the public register. See, entered into the public register with details about the goods themselves and the security agreement. A simpler method of giving publicity to a security interest is is marking the charged goods. This is still sometimes used in the case of cattle. Some countries also employ the method of privileging specific lenders. They endow the loans of certain lenders, usually public held or controlled banks, with security interests or rightful preferential satisfaction. All the borrower's goods, or at least those that have been acquired by means of the loan, are automatically charged. Okay, in absence of any of the above three methods, various indirect techniques are usually employed. The need for sellers to retain a security interest in the goods sold until the purchase price has been paid has been particularly acute in some especially Latin countries. The rule on sales provide the seller with a statutory right of preferred satisfaction. But in most jurisdictions, the seller must make his own arrangements, since the transfer of ownership in the goods is subject to the agreement of the parties. So, for the people who've done consultation, I say what the reason why you don't have a claim in most of your stuff is because there's no agreement. Both parties have to agree. Okay, the seller may retain his ownership in them until he has received the full purchase price. Such as a conditional sale is recognized in many countries even without registration, since it has regarded as a modified sales transaction. If the seller himself is using credit to finance his credit sales, the financier can usually be secured by transferring to him the seller's retained ownership. In some countries, including Great Britain, Their so-called hire purchase method is widespread, especially in sales to consumers. The seller retains ownership but surrenders the goods that the buyer intends to acquire on hire against him, hire to him against a down payment and a monthly rental. If in due course the rental payments accumulate to the sale price, ownership is transferred to the purchaser. Okay, so if in due course the rental payments accumulate to the sale price, ownership is transferred to the purchaser. Did y'all get that? So it's basically saying if you do a lease agreement and the lease agreement comes up to the sales and purchase agreement, or not even a lease agreement, but if you do an installment contract and it's over the or it comes up to the purchase price, then the transfer of those goods goes to the purchaser. So that means that you paid off your loan. So I hope y'all heard that. Here again, but see what they do is they have you transfer your interest back in so that they can still receive installment payments. But there's a way around that anyway. Here again, registration is not usually required since the transaction and is cast into the form of a lease. In the case of the lenders who are not the same time at the same time, sellers, it has been modified more difficult to find adequate security devices. One of the most successful methods has been developed in close analogy to hire purchase sales transactions. The borrower transfers ownership in the goods financed by the loan to the lender, but retains them in possession by means of lease agreement between him and the lender. After repayment of the secured loan, the borrower reacquires title from the lender. Now, when you receive a loan, they'll tell you that it's a non-recourse loan. Okay, this is how they're able to trade and transfer your car loans, your mortgages, because they waive recourse. It's not a secured loan. Okay, so what happens is that you and both the lender have abandoned title. That's how the attorney gets to come into court and steal your property. Under modern economic conditions, it is rarely feasible to deprive the borrower of charged goods, as the raise of no pledge security interest demonstrates, but the goods frequently do not even rest in the borrower's hands. This especially likely to be the case if the borrower is a trader, and he will probably want to sell the goods that he has charged. A manufacturer may similarly wish to replace charged machinery. In these instances, need arise to allow the borrower the desired disposition of the goods and at the same time to maintain the lender's security interest. A number of legal systems, however, do not yet recognize the legitimate interests of both parties in this situation. They may prohibit any disposition by the borrower and may not admit a security interest in the goods that remain in the borrower's hands for a purpose of resale. This problem has been solved in the United States and Great Britain although on slightly different lines in two countries. In the United States, the original registration may provide that the security interest is extended to the proceeds from the disposition of the goods or to the products of the charged goods. In Great Britain, the right to a floating charge granted against its assets by a borrowing company to a lender has the same effect. A security interest proves its legal value when under attack by third parties. If it is to fulfill its functioning guarantee to the lender, uh, preferential satisfaction of his claim. The charged goods must be immunized as such as much as possible against the rights of other persons. The third party is frequently a person who has unknowingly purchased charged goods. The borrowers in financial straits may be unable to resist the temptation of selling charged goods left in their hands to a third person without consent of the lender and without making the proceeds of sale available to him. Most countries tend to protect the buyer, provided he neither knew or ought to have known the existence security interest. If the charged goods are marked, the buyer can hardly claim to have purchased them in good faith. Okay? If the charged goods are marked, I hope y'all got that. Um, but mere registration does not usually give the buyer sufficient notice, since sales transactions cannot be burdened by requiring the buyer to search a register in distant place. The borrower's other creditors can also likely have an interest in the charged goods, but the creditors, as distinct from the buyers, as usually expected to search existing registers of charged goods. If they have neglected to do this, they may suffer the consequence of being subordinated to the lender's security interest. Failure of repayment. If a borrower does not make payment after the secured loan has fallen due, the lender may pursue two different courses. He may enforce his claim for repayment before the courts, just as any other creditor, or he may enforce his preferred position as a secured lender. Remember, they have to be secured. Okay? The rules to be followed in enforcing a security interest differ considerably from country to country, even within a country according to the type of security interest involved. Very often, the lender must sell the charged goods by public sale. I hope most of y'all who do consultations, that's why I try to tell y'all this is why the courts are able to enforce child support orders in court cases, because they do it publicly. Okay. Occasionally, he is permitted to acquire the charged goods himself. If the proceeds of the sale exceed the amount of the secured loan, the surplus must be paid to the borrower, whereas the borrower remains liable for any deficit. All legal systems frown upon a clause that permit a lender to acquire charged goods automatically on a borrower's failure to pay. The rules on a security interest are still strongly national in character. They need unification. The need for unification has, except in few specialized areas, not been very urgent. This is largely because in the great bulk of international sales transactions, the seller, wherever necessary, may secure himself by insisting on payment by letter of credit. But some international concern was the question of the protection of the security interest in those means of transportation that move constantly from one country to another. Two international conventions on securities and ship and aircraft have therefore been concluded. They do not provide uniform rules on security interest, but merely guarantee that an interest validly credited in one contracting state will be recognized in other contracting states. The number of countries that have adopted this convention is limited. Okay, so you got to understand how this debtor-creditor relationship becomes. The debtor-creditor relationship is because there's a general account. So if you have a general account with a lending institution or financial institution at court, when you go into court, they make it when you make a general appearance. That creates a debtor-creditor relationship. So if you make anything general, it's debtor-creditor because it's not expressed, it's not a contract. Okay, it's a security. And in a security, there has to be a debtor-creditor where a contract, both parties have rights. Okay, debtor and creditor relationship existing between two persons in which one, the debtor, can be compelled to furnish services, money, or goods to the other, the creditor. This relationship may be created by failure of the debtor to pay damages to the injured party or to pay a fine to the community. However, the relationship usually implies that the debtor has received something from the creditor in return for which the debtor has promised to make a repayment at a later time. Listen to what that just said. So if you haven't received something from anyone, then how could there be a debtor creditor relationship? So if I go to the bank and I open up a bank account and the bank hasn't credited me, then how can I have a debtor creditor relationship to the bank because they haven't released any credits to me? Or if I go buy a car, once they assign it without recourse to the bank, how can the bank come after me when there's no debtor creditor relationship? Because the bank agrees to indemnify the dealer, but the bank hasn't lent me anything of substance. You see what I'm saying? So I hope y'all got that message. All right. So if the debtor fails to repay to make repayment by the deadline or commercially feasible time limit, and if the routine efforts of the debt collection prove fruitless, then an attorney may commence a formal collection process. Sometimes it is possible to attach the debtor's property, wages, or bank account as a means of forcing payment. See garnishment. It is also possible to secure a lien against the debtor's property, which will permit local off official or law enforcement official to seize uh, the property, sell it at public auction, and use the proceeds to discharge the debt. See liquidation. Imprisonment of the debtor is practice no longer followed. The process of debt collection may be impeded by exemption laws, which provide that certain property of the debtor may not be seized and sold in order to discharge a debt. These exemptions include sums of money, life insurance, and parcels of land. I hope y'all got that. So we're gonna go down to this last section, and then I'm gonna get out. But guarantee. So in law, a contract to answer for the payment of some debt or performance of some duty in the event of the failure of another person who is primary liable, because you become a primary. You're the primary. The account means the primary is liable. Okay, but what it is the bank actually acts as the primary because you haven't asserted your role. So that's why I did a video talking about primary and secondary liability. Okay. The bank is liable for payment, and you're liable for payment or facilitating the payment until you assert your claims. The agreement is expressly conditioned upon a breach by the principal debtor. So if somebody received a note or a draft, they become the debtor. The debtor is not a party to the guarantee. See, when you go into the car, when you get a car loan, you get a car loan through the dealership, but the dealership assigns it without recourse. And the grantor or the guarantor is not a party to the principal obligation. A contract of guarantee must be distinguished from a contract of indemnity. Okay, look this stuff up, in which the indemnitor is primary liable if the conditions of the agreement are fulfilled. So This is where I say that there's always a game of you switching between the bank and you. Okay, this distinction is important for contract of guarantee. Unlike one of indemnity, is not enforceable unless it is evidenced by some note or memorandum or of writing. So we're gonna get to payment, and I'm gonna get out of here. I know I was supposed to. Okay, no, payment's too long. I'm out. But I hope most of y'all understand these terms. I'm just gonna read the rest of this on my own. But I try to do these videos to make law a little bit simpler for you, so you're not just on this internet just flailing your arms around. I'm out.